We don't.
Probably is.
All rise. Superior Court of Fulton County Atlanta Judicial Circuit is now in session. The Honorable Judge Scott McAfee presiding. Court will now come to order.
Thank you all. Please be seated. All right, we are back on the record with 23 SC 188947 with State versus Sean Still. We had 3 motions noticed for today that counsel had requested oral argument on. And so if we could start out by having counsel who will be arguing today identify themselves for the record, starting with the state.
Good afternoon, Your Honor. Donald Wakeford here for the state today, along with Will Wooten. I believe he and I will be presenting argument primarily, although we're joined by Daisha Young and Alex Burnick, who may also have things to say.
All right, thank you. Welcome, Mr. Wakeford.
Good afternoon, Your Honor. Tom Beaver with Smith, Gambrell, and Russell. I will be making the argument today along with my colleague who is here, Cole McFerrin. So we will both be presenting to the court.
All right, Mr. Beaver, are you authorized to waive your client's presence today?
Present, yes, Your Honor.
All right, thank you. Okay, well, Mr. Beaver, they're your motion, so if you want to take them in a particular order, you can go at it. I would imagine it makes sense to have 1 by itself and then 2 and 3, since the judicial notice of facts, I think, is tied up in
Yes, we'd be happy to go in that order.
everyone you want to start with.
We will start with the ones that cover the issue of public officer, as well as the lien document issue, as well as then the jurisdiction issue with respect to the Secretary of State and also the governor's office. We will then move to what we refer to as the literal truth defense or the objective truth defense. We will then finish with the motion asking the court to take judicial notice of certain documents. But before I start, Your Honor, since this is the first time that I've been in front of the court in this matter, I wanted to explain how the defendant Sean Still fits in this matter relative to all the other defendants who have been charged. First of all, Senator Still, he was not a senator at the time that these events occurred. Rather, after the meeting on December 14, 2020, is when he ran for office, was elected, and then was indicted afterwards. Mr. Still was indicted for his activity on 1 day and 1 day only. The meeting on December 14, 0 beforehand and 0 afterwards. The indictment goes to a meeting that he attended that lasted approximately 30 minutes. He has only been charged for his activities as an elector, nothing else. His RICO charge and the 8 substantive counts are all with respect to assembling peacefully with other citizens for 26 minutes precisely, listening to information about a lawsuit seeking redress from the government in terms of the outcome of the election. That is specified in Act number 78. That is, he was encouraged to attend the meeting, and signing 2 pieces of paper, as we will specify to the court. That is for impersonating an elector, for forgery, for making a false statement, all 8 of those substantive charges. All are for attending that meeting and signing 2 documents. That makes him essentially unique among the defendants in terms of not being involved or charged in any other fashion. From the transcript, which we received from the state in discovery of the meeting that took place, which we filed as an attachment to our plea and bar and our motion to quash, we requested that the court stipulate to the authenticity of the certified copy of that transcript that they produced to us. That has not been stipulated to yet, so we have moved the court to take judicial notice of that transcript. Everything charged against my client is based on what happened in that meeting, which is covered by that transcript, which is the highest and best evidence of what occurred at that meeting. We also received a video of what occurred at that meeting, provided by the state in discovery. The transcript from that video, if you follow the transcript and mesh it with the video, they track word for word with one another. Sean Still qualified to be a Republican elector 9 months prior to the meeting occurring. It is not as if he was contacted a few days before and said, hey, we want you to be an elector. Quite the opposite. I want to cover with the court the issue which is raised in count 19. It is mentioned that Sean Still was the secretary of the meeting. It is clear from the transcript at pages 10 to 11 that that was somewhat of a fluke. More specifically, Carolyn Fisher started as the secretary of the meeting, took the role halfway through the meeting when they get ready to count the ballots. It is noticed that his name erroneously is on the documents as the secretary of the meeting. The chairman of the meeting, Mr. Schaefer, makes a motion for him to be named as secretary. That motion passes. He accepts the position as secretary and the balloting starts. That's how he became secretary, so they did not need to reprint the paperwork that was being shown at that meeting. Let me paint for a moment to the court the scene of the crime according to the indictment that my client as an elector walked into at 12 o'clock noon. Transcript shows that's when the meeting started. It didn't start at midnight. It wasn't held in the darkness of the night. In Act 57, it explains that it occurred at the Georgia State Capitol, not in some random warehouse somewhere that was difficult to find. The media itself was present for the meeting. That is, it was reported on. It was live streamed. It was photographed. It was filmed. In fact, the whole world was watching this meeting. As is described in Act 158 and also Count 40, there was a court reporter there in the room. That's what my client would have seen when he came into the room. It was pretty clear that nothing was being hidden, just like the court reporter who is here today. What was happening was being taken down. It was pretty official looking to an elector who just walked in the room. There was also a videographer in the room, much like the camera which is here today, taking down what was taking place. Not hiding, pretty obvious, pretty clear someone is taking down the entire proceeding. And there, the electors, including my client, listened with 15 others to the head of the Republican Party, David Schaefer. That's where the encouraged part comes in Act number 78. There's the transcript that shows that my client with 16 others listened to a member of the State Bar of Georgia, an elections lawyer, speak. Ray Smith, that lawyer, introduced as the lawyer for the Trump campaign, who had practiced more than 30 years as of that time. My client, Sean Still, operates a swimming pool construction company. He was not a lawyer at that time. He has never taken a law school class. After that, 14 people walk up and sign their ballots, as is described in Acts 78 to 82. He is number 15. And when you look to see what he saw in terms of the Republican electors, from the eyes of Sean, who walks into the room, who does he see in this gathering? The head of the Georgia Republican Party, a retired school teacher, an active school teacher, another lawyer, also an elections lawyer, in addition to Ray Smith, a former Georgia state senator, a current leading Georgia state senator, a prominent businessman in Metro Atlanta who owns a number of well-known franchises here in the city, an extremely successful businessman, an entrepreneur from South Georgia, and of course, the lawyer for the President of the United States. Your Honor, one can disagree with their politics, but it is hard to imagine a gathering of more solid citizens, if you will, than the ones who were assembled in that room that my client was present in that day. It's not exactly the rounding up of the usual suspects for the commission of a crime or a fraud. It is not exactly a gathering that anyone would come into and upon entering would think that this group is up to no good. It is hardly your normal setting for a racketeering act, and it's hardly your normal setting to think that a fraud is being perpetrated. So what is it that is actually said to Sean, as well as to the press, prior to the ballots taking place? From the transcript, number one, the lawyer confirms that the elector nominees, and this is what they were referred to as, that they were there to cast their ballots for president and vice president to be used in the event that the vote flipped from Democrat to Republican. More specifically, they were told that there was a lawsuit that had been filed by then President Trump and by David Schaefer challenging the Georgia vote results. That is, it was filed under the Georgia part of the elections code, and it was to redress grievances with the government. More specifically, whether there were irregularities in the voting or not, and whether an audit needed to take place. As I recall from my high school civics class, there is a right to assemble peacefully and to redress grievances with the government. That is addressed in our plea in bar and will not be specifically argued before the court today. It has been fully briefed by both sides, and both sides are relying on our briefs. But they were told that that lawsuit had not been ruled on yet. The lawsuit, by the way, is not listed as an overt act in furtherance of the enterprise or the conspiracy. There's nothing that challenges the legitimacy of that lawsuit in the indictment. They were told specifically they had to cast their ballots that day, as otherwise the legal challenge would be moot. They were told that there was legal precedent for doing this from Hawaii in the 1960 election involving Kennedy and Nixon. They were told that the meeting and balloting were being conducted in accordance with the Constitution of the United States. And the bottom line was, if they did not vote their ballots and the state flipped, that the votes for Georgia would not be counted. That's what my client, who is an elector for the first time and a businessman, that's what he heard. Your Honor, I've practiced criminal law as a federal prosecutor for 6 years and as a defense lawyer for 30. I must say I've never seen a fraud perpetrated wide open in front of the public, with a court reporter present, with a videographer present, with the media present, in broad daylight in front of 15 other people. From Sean's perspective, it's hard for me to imagine how he would deceive anyone when one looks at the transcript and you tell them exactly what you are doing, why you are doing it, you record it, and then you send it to exactly whom you say you are going to send it to. It's interesting to me in terms of how in the world would it make sense to sign fraudulent documents and then send them to the chief federal judge here in Atlanta, or for that matter, the vice president of the United States, or for that matter, the same institution which holds our Constitution and our Bill of Rights, that is the archivist in Washington, D.C. I've never seen that in a fraud case before, and I suspect I will never see it again after this case. 26 minutes after he entered the room, Sean leaves the room. I've looked at millions of pages of discovery, and I've seen nothing other than Sean still thinking that when he walked out of the room, he did what he was supposed to do as an elector. My view, obviously I'm his lawyer, but is that Sean Still should have never been charged in this case. And I now want to present to the court the 4 legal reasons why the substantive counts against him should be dismissed. The others, such as the count 1 RICO, have been fully briefed, and we will rely on our briefs. And with that, Your Honor, I'd like to ask to share my PowerPoint with the Zoom here. Good. Your Honor, as I said, the first argument in our demur is going to be the one on public officer. I will go through first what the actual charges are against him in this regard. The first one being count 8. There, the charge is that Sean, on that day I spoke about, the 14th day of December, unlawfully falsely held himself out as a duly elected and qualified presidential elector from the state of Georgia, a public officer, with the intent to mislead the several people I just mentioned, the President of the United States Senate, the Archivist, the Georgia Secretary of State, Chief Judge of the U.S. District Court for the Northern District of Georgia, into believing that he actually was such an officer by placing in the U.S. mail a document which we will specify, the certificate of votes of the 2020 electors from Georgia. That is count 8. The charge itself, OCJ 16-10-23, states that a person who falsely holds himself out to be one of 3 categories, a peace officer, or, this is the key, other public officer or employee. It's the other public officer we're going to fight about, with the intent to mislead another into believing that he actually is such officer, commits the offense of impersonating an officer. So there are 3 buckets that are described in that statute. The first bucket is the peace officer bucket. The third bucket is the public employee bucket. The bucket we are focused on is the central bucket, what it means to be an other public officer. Now, the statute itself, interestingly, does not define what other public officer is. And the case law doesn't define it what a public officer is either. The cases cited by the state do not concern public officers. They concern peace officers and public employees. Specifically, the case of Libri, which is brought to the court's attention by the state, is, in that case, it involved a peace officer, bucket number 1, because the defendant represented that he was an investigator, that he identified himself as an agent, he used common police technology, and the defendant led others to believe that he was part of law enforcement and was a top-notch investigator. The indictment charged the defendant with impersonating a peace officer, not the second category. It's similar for the Garrison case. There, also a peace officer, the defendant wore a dark mask, brandished guns, shouted that he was a federal agent. In the Kennedy case, that was a bucket number 3 case, public employee. The defendant represented himself as an employee with the Division of Family and Children's Services. So, because there's a question mark in terms of what other public officer means, since 16-10-23 doesn't describe it, we've got to look to other Georgia case law to get a handle on that.
Let me pause right there. So in your research on the statute, you're saying you haven't found a single published opinion that used the other public officer designation?
Under 16-10-23, we have not. There's a what other public officer means. Yes, Your Honor. We have found cases under which describe the factors that a court should look to in deciding whether someone is a public officer in the cases involving the writ of quo warranto. That's in the statute 9-6-60. That writ says it may.
Before we jump into it, though, I think you got to build a bridge for me here, which is, public officer appears all throughout the codes and either, election ethics, title, 45 with just the state government. Why do we jump right to quo warranto when we're trying to decide what is a public officer? Why don't we go to any of the other code sections that talk about public officers? Maybe this one has more helpful case law for you, but why start here? Why even go here at all? Why not just say we're going to look at a dictionary and decide what we think public officer means?
Certainly a valid question, Your Honor, and let me address it, which is, first of all, the elections code, we would say, does not apply because it wasn't charged under the elections code. And there were plenty of elections code charges that could have been used. Not one of them was used. So the definition, if you're not going to charge it under that statute, our position would be, then you don't use the definition of public officer under that statute.
Quo warranto is a civil action. They haven't brought a petition on it. No one's trying to question someone's right to public office. How does that have any more applicability than the election code?
Well, we would say, Your Honor, that because it lays out what the factors are that the court should look at, that we think that that's where the court should go in this case in terms of approximately 5 factors.
And I agree with you that there seems to be a more developed body of case law with factors and the test and things we can look at when it's come up. But I'm still just not seeing why we even get into that pool and swim around, right? Why there?
Well, I would say that, first of all, one could swim around in that pool as well as the other pools to come up, since it's not a defined term under the statute. Certainly, the court can look at any law that it wants to, any cases that it wants to. What we were struck by is the idea that, okay, to look at a public officer, what does one look to? You look to whether they take an oath, you look to whether what their salary is, you look to what they do on a day-to-day basis, you look to see what the breadth is of what they can do under their position. You may look at other insignia, such as whether they have a seal, et cetera. But our thinking.
And does that then, though, what that causes me to worry about, though, is if we're going to start here, and if the standard is just we can look anywhere to figure out what else a public officer is. Again, it comes up in all sorts of different titles all over the code section. Can we be confident we've done a survey of every single title and every single little body of case law defining a public officer? I mean, before we consider quo warranto, do we then have to consider them all? And I don't even have any idea of what that might even look like.
Well, it's certainly an appropriate question, Your Honor. And if the court wants us to do a briefing after this hearing today, where we look at these other areas allowed for the court, we can certainly do that. But there are 2 things that I would call the court's attention to, this being a criminal case. One is that when you are, is that a person to be charged with a criminal case needs to have fair notice of whether what they are doing is a crime. So if there's a debate under this statute on impersonation as to whether an elector, in this case one of the Democratic electors, is a public official or not, it's not fair for a client such as mine, who runs a pool company, to be in the dark whether he's committing a crime if he sought to impersonate that public officer. Now, going back one step simply here is that it's pretty clear from the transcript that he and others were being told this is only going to be used in the event that that lawsuit of Trump and Schaefer is successful. But hypothetically, if you're the same client and the question is, are you impersonating a public officer? It's clear if I impersonate a peace officer that that's wrong. That's intuitively wrong. If I walk into a room and make it out as if I'm being a peace officer, everybody knows that I have certain things that I can do to them as a police officer, okay? If I hold myself out to be a judge, everyone realizes a judge has certain things that they can do to them. If you're a public employee for many positions in the state, there are certain things that come with that, like the example, I think it was Garrison, where you've got a, maybe it was the other case, but it's where you have the Department of Health and Human Services, they can take your child away. Okay, that immediately puts somebody on alert. But if someone is told, well, you know, I'm an elector for president and vice president of the United States, it's not clear that if you're impersonating that person, that they fall in the category of a public officer. It's not clear that that person is a public officer at all. For most people, they don't even know what an elector is. So notice is one thing. The other thing, Your Honor, is that if the law, if all of Georgia law is looked at to see what a public officer is, and it is unclear, then in Georgia law, the rule of lenity would apply in a criminal case. You can't put a man into the penitentiary when it's unclear whether he's committed a crime or not. Now, I know the state has taken the position in the past in other parts of this case that the rule of lenity in Georgia only applies to sentencing, and we absolutely disagree. Rule of lenity applies both to sentencing, but also to charging, because again, nobody in Georgia would want a situation where someone's being charged with a crime and it's unclear whether it's even a crime. So that's our problem with that middle ground of other public officer. When you've got clarity on peace officer, you've got clarity on employee, but you've got a unclear area of what a public officer is. And the case that, as you might imagine, is our favorite case is the one of the case. It's just an old case. It's still good law that finds that it's that a grand juror is not a public officer. And they look at the same factors as we would look to with respect to the different things I just mentioned. And if I may just skip ahead to point out to the court what those, identification with the government would be another factor. But in this chart, we compare the two of grand jurors and presidential electors. This is the McDuffie case. Both are created by statute. A presidential elector is also created by the Constitution. Both receive simply a stipend. I know the state takes the position that the $50 for the one day that the elector serves is a salary. We say, no, that's a stipend. The duration for a grand juror is only a few days. In the federal system, as the court knows, that may last for 6 months. For an elector, it's 1 day every 4 years. The scope of the duties are set by law. We know for grand jurors, they indict people who have violated criminal statutes. For a presidential elector, they meet and cast a ballot on a single day and don't really even have a say-so who they're going to cast it for. Everybody who's a Republican in 2020 cast it for Trump. Everyone who's a Democrat cast it for President Biden. So there were two things, though, that in the McDuffie that the court looked at in terms of the public office, and that is the element of tenure and the element of duration. And they found that lacking with respect to a grand juror. And we were urged, Your Honor, that tenure and duration are lacking also in the instance of a presidential elector. That is our presentation with respect to public officers. We can go to the next point unless you want us to take a break and have a response from the state at this juncture.
Yeah, I think that makes sense.
Judge, I'm going to start with one of the questions that the court had for Mr. Beaver, which is why do we need to get into the case law? Why can't we just look at the dictionary definition? And it's a great question, and it's something that our appellate courts do all the time. And so I want to start with the dictionary definition of a public officer. And I'm going to give you two. I'm going to give you the Merriam-Webster dictionary definition, which is a person who has been legally elected or appointed to office and who exercises governmental functions. And then I'm going to give you the Ballantyne's Law Dictionary definition, which is, of course, a little bit more in depth. An incumbent of a public office invested with certain powers and charged with certain duties pertinent to sovereignty. Such an officer is required by law to be elected or appointed, who has a designation or title given him by law, and who exercises functions concerning the public assigned to him by law. And so we agree with the court. That definition tells the court all it needs to know. These two definitions kind of tell the court at least a starting point. And so,
And not to get too in the weeds, but I might have to. Do you
Sure.
know if those were contemporaneous definitions, those dictionaries at the time the statute was passed?
I don't know that, Judge. Those are the definitions as of today. I don't know that. I can check. But kind of turning to those factors, and many of these factors are very consistent, if not identical, to the ones that are set forth in the Quo Warranto cases that the defense relies on. Again, we don't think that that body of case law is applicable here for the reasons that the court pointed out. But even if it is, they support our position. So let's start with the election requirement.
But before we get into it, the Quo Warranto part of it, do you agree that you haven't been able to find a case that applied this other public officer designation of the statute?
I haven't looked at that specifically, Judge, because I haven't pulled the indictments on these cases. So I can't say for sure what the charging language is. I don't know. I can more than happy to try to pull those indictments and find out and submit them to the court.
Well, and we may not need to just do the indictments if they made it clear in the opinion itself, but if that makes a distinction
Sure.
at all. But let's say that they do not, and we can't explicitly say, hey, here's a case that applied to other public officer. Or would you say that defining that term, we just stay solely within Title 16 and we go no further?
Well, I think when the appellate courts have looked at something like this, the question is, what does the term mean to a person of ordinary intelligence? And so, there's a lot of things you can look at. You can look at the election code, I guess. You could look at the Quarento cases. You can look at the dictionary. But public officer isn't some complex, arcane term. It's something that I think most people would understand the meaning of. It's a person who holds a public office. It's not complicated. So I don't think, just because there's not a case that says this is what public officer means, or there's not a statute that says this is what it means for purposes of 161023, that doesn't mean that 161023 we can't use that statute to charge. I mean, I agree. I don't know that there's one that comes to mind, a case that comes to mind where it's explicitly defined, but again, these are words that people of ordinary intelligence understand the meaning of. And so I just want to briefly dig into kind of using both the dictionary definitions and, for whatever it's worth, the Courtroom case definitions, because I think that they all show that presidential electors are public officers. So number one, they're required to be elected under Georgia law. OCGA 21-2-10 says at the November election to be held in the year 1964 and every fourth year thereafter, there shall be elected by the electors of this state persons to be known as electors of president and vice president of the United States and referred to in this chapter as presidential electors. So they're required to be elected under Georgia law. That same statute, OCGA 21-2-10, gives them an official title. They have functions concerning the public, so government functions that are assigned to them by law. That's in OCGA 21-2-11. Says the presidential electors chosen pursuant to this code section shall assemble at the seat of government of this state at 12 o'clock noon on the day which is or may be directed by the Congress of the United States, and shall then and there perform the duties required of them by the Constitution and laws of the United States. And so, it's defined under Georgia law, and then Georgia law references any additional duties that are provided by federal law. The 12th Amendment says exactly what presidential electors have to do. By law, they have to meet in their respective states. They have to vote by ballot for president and vice president on behalf of the citizens of the state. They have to tally the votes. They have to sign and certify those tallies. And then they have to transmit them to the seat of the government of the United States, directed, of course, to the president of the Senate. And I think there's been some implication that presidential electors, don't have any discretion, that they just are ministerial, that they just rubber stamp what the outcome of the popular vote is, but that is not true in Georgia. Some states do have laws that require presidential electors to follow whatever the popular vote is, but in Georgia, that's simply not the case. There is no law that binds them to vote any particular way. If a, Democratic presidential elector in 2020 had wanted to vote for Donald Trump, they could have. If they wanted to vote for, Daffy Duck, they could have. So this idea that they just serve a ministerial administrative function is not true. They're charged by law with exercising their jurisdiction or their discretion to cast a vote on behalf of the people of this state. Again, and we acknowledge in our written response that the compensation is small. It's $50 plus, per diem and mileage. But there is a compensation that's provided by law. That's at OCGA 21-2-13. For what it's worth, the election code refers to the office, quote, office of presidential elector in multiple places, primarily in code sections. Well, it's in 21-2-132A and 21-2-132E. Both of those deal with nomination of electors or nomination of candidates for the office of presidential elector. Again, as the court pointed out, the election code definition, I don't know that the court's restrained by that definition, but again, it reinforces the same idea. And I'll read the election code definition of public office, which is at OCGA 21-2-10. And that definition is every federal, state, county, and municipal office to which persons can be elected by a vote of the electors under the laws of the state. So certainly meets that definition too. They're elected into this office. Again, I disagree with the idea that the cases we cited, Kennedy, Libby, and Garrison, I disagree with the idea that they don't apply at all. I think that they certainly represent that our appellate courts have kind of interpreted the application of 1610-23 in a broad way. This court's heard arguments that, you know, and not necessarily just in this motion, but other defendants who have argued this issue, that 1610-23 only applies to police officers. That's not true. We know that because of Kennedy. We've heard that they have to be real officers, of an actual officer, and we know that that's not true because of Libby. We've heard that they have to be state officers. We know that that's not true because of Garrison. And so in each of the cases where, there's something other than just a police officer and a person is convicted for impersonating some other office, our appellate courts have upheld those convictions repeatedly. Again, we don't believe that the quo rento cases apply, but if they did, I think that they, again, support the conclusion that presidential electors are public officers. And I would turn specifically to the Brown versus the state case, 266 Georgia 44. I believe it's the most recent quo rento case that was cited. I can't say that for certain, but it's a 1995 case, and it sets out basically two requirements. One is that the person has a designation or title given by law, which that certainly applies here. And two, that they exercise a government function assigned by law, which our code completely establishes those two things. Additionally, from Brown, the conclusion that someone's a public officer is not altered simply because their duties are narrowly confined. So just because presidential electors meet one day, I don't think that that's of any relevance. They hold an elected position, all the other things that we've gone through. Additionally, from Brown, the mere fact that a public officer may not be entitled to all of the trappings of public office does not make the office any less public. And so, certainly presidential electors don't have staffs. They can't appoint individuals, to act on their behalf. They have a very limited role, but at least in the quo rento, setting, I think that we meet the requirements there. I just want to, again, emphasize there's this argument of rule of lenity or fair notice. Number one, since the first version of the Georgia Code, it has been the law of this state that everyone is presumed to know the law. So there's a presumption that every person, including Sean Still, knows what the law is. And not knowing that what you did is illegal is not a defense to what you did. Additionally, I kind of started with this, but fair notice, when you consider fair notice, I think the question is, does a person of ordinary intelligence understand what a term means? And again, public office, public officer, these aren't arcane terms. These aren't, something that someone scratches their head and thinks, what in the world is that? It's clear. In fact, I think Mr. Beaver said that a judge would be a public officer. I'm not going to take a position there, but a judge certainly isn't a peace officer, certainly isn't a public employee of an agency. So, if a judge is, if it's so obvious that a judge is a public officer, I'm not sure why the one office that these defendants are charged with impersonating is the one office that just can't be a public officer, that no one would know is a public officer. I don't see how those arguments jive. I think we've addressed all the other arguments in our written submissions, so I'd take any questions the court has.
All right. Thank you, Mr. Wooten.
Thank you. Oh, Judge, your question about the definition, looks like the third edition, the dates definition versus the statute. The third edition of Ballantyne's Law Dictionary is from 1969, and 1610-23 was passed in 1968. So they are very much contemporaneous. Thank you.
Your Honor, briefly in response, the case that was just mentioned, the Brown case from 1995, 266 Georgia, that is the juvenile intake officer case. That's one where the court beneath held that they were not public officers and the Supreme Court held that they were. Part of the factors that one of the factors that the court looked at was to juvenile intake officers have the ability to decide whether a juvenile is kept and is locked up or is released when they are presented before them. The court said that you can look at the factors of creation, duration, and emoluments for an office to determine whether someone is an officer or not. They do cite the McDuffie case, which is one of the pro warranto cases. That's one on the grand juror not being a public officer. And they conclude that with respect to the issue, that it's whether the title given by law and the exercises which are function concerning the public make are factors for the court to look at. I would contend that if you're a juvenile intake officer, people would view you as either a public officer or as a peace officer, more so than an elector who serves on one day, is paid $50, goes to one meeting, casts one vote, and at least in the 2020 election, you had 16 for 16 Republicans voted for then President Trump, 16 for 16 Democrats voted for President Biden. In the McDuffie case, what they said was it is two things, tenure and duration, which the court should look to. That's what they focused on their decision with respect to finding that a grand juror was not a public officer. And then I would cite the court to the Morris versus Peters case because that's where it lays out the factors of oath, salary, operation, scope of duties, all being signs of official status, but that none are essential, and that indeed a court should look to see whether the officer is, quote unquote, identified with the government. There they found that a grand juror was not identified with the government. We contend that the electors are not identified with the government in the same manner that either a peace officer or an employee is. With that, I will move to our argument, Your Honor, next on documents.
All right, and Mr. Beaver, since we still have some ground to cover and you had a generous opening there, I'll give you about 15 minutes on this one, okay?
Okay. All right, Your Honor, this one starts off with count 14, criminal attempt to commit filing false documents for Sean Still, again on the day of December 14, with the document entitled Certificate of the Votes of the 2020 Electors from Georgia. That document was sent to the chief judge and that with the intent to knowingly file, enter, and record said document in the court of the United States. We've stated before what that document says. The question under 161020.1B1 is what is a document? Because that statute holds that if you knowingly file, enter, or record any document in a public record or court of this state or of the United States, knowing or having reason to know that such document is false and contains a materially false, fictitious, or fraudulent statement or representation. The question is, what is a document under this statute? Here's the definition, which is confusing. It means information, number one, that is inscribed on a tangible medium. So that would be like a piece of paper. If you write the word public officer on a piece of paper, that would fall in that category, tangible medium. Also, stored in electronic or other medium and is retrievable in perceivable form. That would be this PowerPoint. And here's the key phrase, which the court has addressed previously in the Chesbro case, but shall not be limited to liens, encumbrances, documents of title, instruments relating to a security interest in or title to real or personal property. Fairly specific real and personal property type of documents. Then has the blue part, which expands it. And the question is, how much expansion? Other record statements or representations of fact, law, right, or opinion. So we say you apply the rules of statutory construction to this statute. And there are 4 rules that all apply at the same time. That you construe the statute according to its terms, to give words their plain and ordinary meaning, and to avoid a construction that makes some language mere surplusage. We contend that in this instance, if you include document as being any documents which the state would want so as to include it in this criminal charge, then that language in the statute has mere surplusage in it. That you consider the words in context, not in isolation. You consider the statute as a whole, and you avoid ascribing to one word a meaning so broad that it is inconsistent with its accompanying words, thus giving unintended breadth to an act of the General Assembly. Your Honor, here we say that what a document is under this catch-all phrase of other records, statements, or representations of fact, law, right, or opinion makes the definition of document ambiguous because it has all of those specific kind of documents, the liens, et cetera, just before it. And there are 2 canons of construction the court is aware of because Your Honor indeed cited them in the Chesbrough order, that being as jesdem generis and nascitur societ. And excuse me for butchering the Latin, but I do understand what they mean. The first one is basically you interpret it of the same kind. When a statute or document enumerates and name several particular things, a broader term is construed as being of the same kind or class with the things specifically named. So applying it here to this is you would look, if there are documents that are broader than that they would be of the same kind or class as the liens, encumbrances, documents of title, et cetera. We would also say that the other nascitur socii is known by its associates, and that is words, like people, are judged by the company they keep. When you apply it here and you look at this Chesbrough case. The first one is a companion case here. Well, it's a case, sorry, by your fellow Judge Adams, the Harned versus Piedmont Health Foundation case, because there specifically Judge Adams in 2019 found that statute did not apply to medical records because the statute applies solely to liens, encumbrances, documents of title, and instruments relating to a security interest in title, real or personal. So we would call that to your attention and urge the court to give that case serious consideration in terms of looking at this issue. The other case is the Wilson case versus Clark University, 339 Georgia Appeals. That one is one that applied the canons, both of those that I just mentioned to the court, even though in that case there was the presence of the phrase include, but are not limited to. So I would urge the court to take a look at the Wilson versus Clark case because that is different than this court's finding in the Chesbrough case that once you've got shall include but not be limited to, it supersedes those statutory canons. There was an amendment in 2014, but if the court looks to the amendment, it did not change the narrow definition of what document means. Instead, what it did was it made it such that the statute did not apply simply to public employees, but it did not expand the statute's scope to all documents. And I want to mention to the court that in terms of the rules of construction, our concern with this is that if you go back and look at that language of the statute, if it was true that the word document means all documents, any kind of documents, then the critical part of this, that is the liens, encumbrances, documents of title, instruments relating to security interest in or title to real or personal property, that would be pure surplusage. That language has been in the language since the beginning of this statute. If it's interpreted as meaning as all documents whatsoever, then that is mere surplusage, which would violate the rules of construction. We would also point out, Your Honor, like we did before, that in terms of due process, that according to the Lanier case, the Supreme Court case in 1997, it prevents a court from applying a novel construction of a statute, that under Pitts versus State, the Georgia Supreme Court in 2013 requires the law that a person with ordinary intelligence, fair warning of the specific conduct which is forbidden or mandated. Well, Judge Adams is certainly a person with way more than ordinary intelligence. According to the case that she authored, she would be saying that, well, I don't see it as a document covered by this statute. It also, frankly, it doesn't provide notice to either Sean Still or to someone like him that they can be held criminally responsible for meeting and voting on that date, especially since his conduct with respect to the documentation that he filled out was identical to the conduct in the 1960 Democratic presidential electors from Hawaii. There's also, we would repeat the rule of lenity here, that if there is an issue with respect to the way that that statute should be read, whether it should be read the way that Judge Adams read it or the way that this court read it, that it should be strictly construed against the state and in favor of the accused. So we would ask this court to construe the criminal statute narrowly in this case. And I think I've hit the 15-minute mark or close to it, Your Honor.
Thank you.
Judge, I'll be very quick here. We've argued this before the court multiple times. The court's already rejected this argument previously as to another defendant. We'll rely on our briefing, take any questions that the court may have.
All right, well, let's talk about that Wilson case then, because that is not one which I think I saw referenced in the state's reply, if I'm not mistaken. And I don't recall getting into that when we did this in the fall.
And
I'll open it up
I'm
to
not
any
familiar with the
reactions
case.
to that one.
I haven't read that case, Judge. It's kind of the first time I'm hearing of it. So I don't have a meaningful response to the court. Be more than happy to take a look and submit anything post-hearing.
All right, and just generally pulling it up, it does include a but-see citation to Garner's dictionary where we find that thought in the October order about superseding those two canons with a including but limited to, so that'd be something to parse out.
Okay.
But otherwise,
Thank
we'll
you.
submit it on the briefs. All right, Mr. Beaver.
My only other comment on that one, Your Honor, is from the Wilson case where the court says that it is under the principle of that Latin term es gesdem generis, it is widely accepted that general expressions such as including but not be limited to that precede a specific list of included items should not be construed in their widest context, but apply only to persons or things of the same general kind or class as those specifically mentioned in the list of examples. Similarly, under the canon of noscitur a soci, the words in a document should be understood in relationship to each other, since words, like people, are judged by the company they keep. With that, Your Honor, we will turn to the, and we did cite Wilson, Your Honor, in our reply brief at footnote number 5. So it is before the court in terms of our citation. With that, we will turn next to the jurisdiction argument. Your Honor, the next argument deals with counts 12 and 18, false statements and writings. To start off with, under 161020, a person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, or makes a false, fictitious, or fraudulent statement or representation, or makes or uses any fraudulent statement or entry in any matter within the jurisdiction of any department or agency of a state government, or of a county, the government of any county, city, or other political subdivision. That's the statute that our client was charged under. Now, from the Namias opinion in the case of Haley versus State, and from the Court of Appeals decision in Tesler versus State, what does it mean to have that jurisdiction? A state government agency or department has jurisdiction if the state agency or department has the authority to act on the false statement or the information received. Here, Your Honor, in count 12, here's the charge. Our client, Sean Still, is charged with, on that day of the meeting, with respect to the document that's a certificate of the votes of the 2020 electors from Georgia, with knowledge of the information that it contained. We've cited that before. Said document being within the jurisdiction of the Office of the Georgia Secretary of State and the Office of the Governor of Georgia. Your Honor, our contention is this. So we know the document is the certificate of the votes of those electors. The alleged false statement is that they were duly elected and qualified electors for the President and Vice President of the United States. The relevant agencies are those two, Secretary of State and the Office of the Governor. We'll take the Secretary of State's office first with respect to the certificate. They do not have jurisdiction because the Secretary of State's office, Your Honor, doesn't have authority to act on the alleged false statement or the information received. They simply receive it and they hold it. That's it. Additionally, importantly, the Electoral Count Act, which the court has certainly heard about before in this case and had it briefed, places sole authority in Congress to decide presidential electors after the safe harbor date. In this case, that date was December 8th or so. This meeting took place on December 14th. So the authority to do anything with that document had shifted to Congress, and I'll address that in a moment. We say that holding the document is not doing any kind of act in terms of the false statement or the information contained in the document. Same thing with the governor's office. They don't have the authority or jurisdiction to act, both because of the Electoral Count Act, but also the state's response doesn't provide any specific reason as to how the governor's office has jurisdiction of that first document, that is the certificate of the votes. With respect to the Electoral Count Act, we're going to be very short on this. You've got a three-step process, which has been outlined in our brief, but I really think that this arrow diagram shows it the best. We are in the green box. The blue box is if you've got an electoral challenge which is pending, the court has to issue a final determination by the safe harbor date, December 8, 2020. That didn't happen in this case. The state doesn't contest that fact. The green box says if the court does not issue a decision by the safe harbor deadline, then the House and the Senate of the United States decide which presidential elector ballots to count. They can count the Democrats, they can count the Republicans. It's up to them. That's where we stay, is in the green box in this case. We never go over to the next blue box to the right. That is, if the House and Senate cannot agree, then Congress must count the ballots certified by the governor. So the Electoral Count Act is critical in this jurisdiction issue. Here in count 18, we have a very similar charge. We have that my client, Sean Still, was charged with false statements and writings under 161020 for a different document. This is called Notice of Filling of Electoral College Vacancy. That with knowledge that said document contained false statements, that both Mr. Schaefer, who was chairman, and also Sean Still, who was secretary, said document being within the jurisdiction, again, of those two agencies. The analysis is very similar, Your Honor. Number one, we got a different document. The only other one he's charged with signing. Notice of filling of electoral college vacancy. This is after he got named as secretary and then signs the document as secretary. False statement is that he was secretary of the 2020 Georgia Electoral College meeting, and the relevant agencies are those two. When we turn to the Secretary of State's office, Secretary of State doesn't have jurisdiction because they don't act on the document. Whether the information contained within it is false or true, they simply hold it. Also, by that time, we're in that green box. It is the sole authority of Congress to decide presidential electors once you pass that safe harbor deadline, and that's where we are at. The state's response in this document does not provide any specific reason as to how the Secretary of State has jurisdiction over the alleged false document. When you turn to the governor's office on this certificate of the filling of the vacancy, the Electoral Count Act, boom, again, sole authority in Congress, and whether or not the governor ratifies the filling of the vacancies is not binding on Congress's selection of the presidential electors. So the governor's office doesn't have jurisdiction because the governor's office doesn't have the authority to act on the alleged false statement or the information which has been received. Same three-step framework, same green box that we are in. And Your Honor, with that, we say that under those two statutes, my client's been charged. They should be dismissed pursuant to the demur because neither of the two state agencies have jurisdiction.
Very briefly, Judge, and I'll keep it again short because we've argued this issue multiple times. Just as an initial matter, we maintain that this argument is a speaking demur. It's going to facts that we have to prove at trial. So we have to prove at trial whether or not these documents are within the jurisdiction of either the Secretary of State or the governor. We don't have to prove both, one or the other. And so it's a little bit premature here to be talking about whether or not the state's able to prove that at trial. As the court well knows, speaking demurs are void and the court can't take any action on them whatsoever. But just briefly, because even going outside of factual matters, as a matter of law, both the Electoral Count Act and the Georgia Code impose the authority to act on the Secretary of State's office. Secretary of State's office will take action by showing it to whoever requests to see it. And again, that's
Does any indication that within the jurisdiction requirement and this authority to act standard, any indication that requires some measure of discretion, that it's not just ministerial?
I have not seen anything. I've not seen anything in any case that makes that distinction.
Because wouldn't this fall more on a ministerial end of the spectrum if they're just maintaining something they've been received? They don't have the necessarily authority to reject or accept, or do they?
I'm not sure if they have the authority to accept or reject. Again, I think that's a factual matter that has to be proven at trial that would answer that question. But
Well, not necessarily if it's in the statute or if it's an issue of law, just exactly what they have the ability to do.
what I can say for sure, Judge, is that the Electoral Count Act says that they have to maintain it and provide it for public inspection. Number one. Number two, like I said when I started, we charged it, these documents as being within the jurisdiction of the SOS or the governor's office. So we just have to prove one at trial. So even if that's.
Let's go over to the governor's office then. It
Sure.
says it's required to ratify and cause notice. Again, is there any discretion involved in that, or is that just a ministerial act? And if so, is that to have the authority to act, does that indicate you can go one way or another?
Well, I don't know if there's discretion. I've never seen anything that indicates that there is. The way that I read the statute, it seems that the governor does have to, kind of rubber stamp whatever the selection is. But the statute certainly imposes a duty to act on the governor because number one, he has to do that ratification. And number two, he has to cause notice of that election or that filling of the vacancy to be given to the person who fills the vacancy. So there's absolutely authority to act because there's a mandate to act. And so, if there's a mandate, then there must be authority. And other than that, I would just take any other questions.
I'm just really drilling down on that. Authority to act seems to imply that
And Judge, I think
you see where I'm going with this.
I think where that goes is like if I were to, go to the Secretary of State's office and hand them a document that says I wasn't at work on Monday because I was sick. Well, that has nothing to do with them. They don't have any authority to do anything with that. It's totally outside of their jurisdiction. But here, the both federal law and state law impose actions that must be taken, and so that is authority to act. They have to do it.
Okay.
Thank you.
All right. Thank you, Mr. Wooten.
My only comment before I go on to the next topic would be that indeed under 3 U.S.C. Section 11, it uses the word shall. So there is no discretion by the Secretary of State. The phraseology in the Haley case by Justice Namias at 289 Georgia uses the phrase with the authority to act on it in that instance. And from the Tesler case from 2009, the Georgia appeals case we cite in our brief, they talk about a district attorney's office having the power to act upon information received as a result of a joint investigation, which certainly would be the height of discretion. So with that, we will turn to what we refer to as our literal truth or the objective truth demurrer. And this will be split between myself and my colleague, Mr. McFerrin. I will be doing the front part of the argument. He will be doing the companion motion seeking to ask the court to take judicial notice of certain documents.
Well, let me see if I can perhaps cut to the chase on some of that and just put the ball right in the state's court. Setting aside the general demur and where, defense counsel is trying to go with these judicially noticed facts. Seems to me, regardless of whether the demur is granted or denied, counsel always has the ability to ask for judicial notice of something that's not reasonably in dispute. So I think it might make more sense to reverse it and first ask the state. These 3 facts that counsel is asking for judicial notice under 201, are those reasonably in dispute? I understand maybe the phrasing might be something the state has some concerns with, but those in and of themselves, what would the state's position be on judicial notice of those facts that?
Okay. I figured Your Honor may want to start at this place because it's sort of like, let's set the table before we eat. So what facts are we actually using? The statute that governs judicial notice now was passed in 1981. That is OCGA 242201. Your Honor will notice that it's from Title 24, which is the evidence code. OCGA 242201 is entitled Judicial Notice of Adjudicative Facts. It's what the defendant has cited to say that Your Honor can take judicial notice at any stage of the proceedings and therefore can take judicial notice at the demurrer stage. However, subsection G of that statute makes a crucial distinction that I think is something that we have to consider today. Subsection G makes a distinction between civil and criminal cases. In a civil case, Your Honor is empowered to take judicial notice of a fact and then it is binding on a jury. In criminal cases, it's not. A jury is instructed, you have the option of accepting as true a fact that I, the judge, have taken judicial notice of, but you are not bound by that. So what the defendant is actually asking this court to do is take judicial notice and thereby decide a demurrer to dismiss charges before any jury or fact finder has had occasion to decide whether the facts that form the basis of that notice are true or not. And that makes it inappropriate. I'll also note that the exceedingly rare occurrence of a court taking judicial notice of facts at the demurrer stage of a criminal case, the only two cases cited by the defendant are antiquated by this point, either from the prior century or 2 centuries ago or from several decades ago. And both of them, of course, precede this statute, which clarified the role that facts that are taken under judicial notice play in court proceedings in the state of Georgia. So at this point, I would say the one thing we know for certain is it would be extremely inappropriate for Your Honor to take judicial notice of facts at the demurrer stage and then use those facts to justify the dismissal of counts. So beginning with whether it should be done, which is honestly the more important question, the answer is emphatically no. Because the only reason that the defendant is asking Your Honor to take judicial notice is to decide this demurrer. That is a use that this statute says is inappropriate.
So take that point and recognizing that for the purpose of the demurrer, let's say this is just a motion in limine that we're doing well in advance. What if this was just on its face a motion in limine? Would the state have a position on this as just under purely 201?
In that, it would be very different in that scenario because that governs admissibility. I mean, really, if all we're talking about is can Your Honor consider something, is it admissible? That's one statement. That's one determination. That's all that this statement is speaking to, really, is admissibility and the burden placed upon the party who would like a fact to be recognized. It's
just preventing them from having to come in and bring in witnesses and establishing something that no one's actually disputing.
Right.
So just purely keeping it in the box of, the evidence that can be stipulated to a trial. Are there any of these 3 things that counsel has highlighted, things that the state is disputing?
Well, we're not, let me be very clear, we're not stipulating anything. So they're all disputed.
Are you reasonably disputing them, I guess, under the words of 201?
Well, again, Your Honor, if we're incorporating 201 into a demurrer stage, let me tell you how this
I'm not
plays
saying
out.
I will, and I'm not saying I am.
This is why I'm saying we have to, we are, because if we're gonna put this square peg in this round hole, then yes, I have to dispute them. Because you know what happens next is I have to say, okay, if the court's going to take judicial notice of these documents to establish these facts, then I have to make an oral motion instantly that Your Honor take judicial notice of the actual document mentioned in the indictment, which is not included in its entirety in the indictment, but forms the basis of the charges, and which lays out in plain English how the defendant committed these crimes. And so it is an answer to the evidence that he's put forward. And now suddenly we're having a summary judgment motion, which is exactly what a demurrer is not supposed to be. That's why trying to apply 201 in this way is inappropriate and unworkable, because you're going to turn every demurrer into a battle of conflicting documentary evidence, because each side can just say, what's your reasonable dispute? I mean, we can call up the National Archives this afternoon and get a copy of the document that forms the basis of the charges in this indictment. That's not open to reasonable dispute. The document exists. And I don't think even opposing counsel would get up and say, that's subject to dispute. But that doesn't mean it should be rightfully considered at the demurrer stage here. That's not what demurrers are for.
Okay, and again, I take that point, but let's say, is your position then changed dramatically if today the demurrer is denied and tomorrow this motion is then rescheduled for judicial notice under 201? We're past the demurrer stage and he's asking for the exact same thing.
I understand that seems odd. It would require this is the problem that we face here, where.
I know I know, I can recognize the concern that it's not going to stay in its little box.
Right.
But if it does, then what's the legal objection to this motion, solely this motion?
The objection to this motion, if you're saying you're taking it independent of the demur, you're
Right.
saying just take judicial notice. The state is not prepared to stipulate to any facts. This requires us to accept facts prior to trial. He's trying to use 201 to set the evidence before trial, and the state would, under the statute, refuse to acquiesce and would dispute. I think that if we're trying to use this motion as a way to bypass lengthy evidentiary problems at trial, then that can be the subject of a stipulation between the parties. I think what I object to at this stage is the use of this statute by one party to sort of put the other party on its back foot before motions in limine have even been heard, to try to set what evidence is going to be heard at trial. And at this stage, the state would simply object to that process and would refuse to acquiesce, I suppose, just because of the position that we're being put in. But I can't really divorce it, Your Honor. Although I know you're asking me to, I apologize. I can't really divorce it from the current proceedings, which is that it's not just that it is instantly being used in a way that the state is vehemently objecting to and showing, Your Honor, is inappropriate under the very terms of the law. So I just don't think it should be entertained when it's clear that its sole purpose at this stage is to provide Your Honor with some kind of end run around the rules regarding general demurs.
All right. If it seems, well, if parties aren't stipulating, and is really the only reason you are interested in this at this point is solely for in support of the demur.
Well, certainly we are here on a demur, Your Honor, and I think I'm going to flip what I had planned to do and have my the court should take judicial notice of them. Then following that, I would make my argument in terms of why we have a demur based upon those if the court decides to take judicial notice of them. So if we can proceed in that manner, I think it'd work better since we've turned things around a little bit. Not my approach.
Sure.
One for the court, one for. Let's see, did you give one to them? Yeah.
Hi, good afternoon, Your Honor. As Mr. Beaver said, I'm Cole McFerrin with Smith, Kimbrell, and Russell, representing defendant Still. All right, so I had a nice presentation plan, but I think we might be better off just getting straight to the point of this. Motion to take judicial notice. We got three basic facts, right? Sean was elected, Sean was qualified, Sean is from Georgia. The whole crux of the state's response is that they don't want to stipulate to any facts. Well, under 201, stipulating to facts has nothing to do with our analysis here, right? So under 201, our focus is on whether they can reasonably question the accuracy of the source these facts are coming from, right? And we have 5 documents here. That's the Certified Rules of the Republican Party. Then that is the Declaration Affidavit to be a presidential elector. That's the certified copy of a list of presidential elector candidates for the 2020 election, the Georgia Secretary of State's list of qualifying, and Governor Kemp's certificate of ascertainment, right? These are exhibits A through E to our motion and the binder before you. The state didn't present any argument on why the court can't take judicial notice based on facts based on these documents. That's because the accuracy of these sources cannot be questioned. Georgia law is clear. Documents that are on file with government entities, governor's office, secretary of state, you can take judicial notice of facts from those sorts of documents, right? These cases are cited in our motion. I'm not going to repeat the citations here. All the citations are in the motion for you and your clerks. It's Wisner v. Gullidge, Riley v. Georgia Association of Club Executives, Kingdom Retail Group versus Pandora Franchising. All of those cases show that you can take judicial notice of facts that are apparent from documents on file with the Georgia Secretary of State. That's the analysis. Stipulation has nothing to do with it. We can move on to Exhibit E. That's Governor Kemp's certificate of ascertainment. The document, if you move to Exhibit E, you'll see it has Governor Kemp's signature. It has the stamp of Georgia. This document is available on the National Archives website. That's the Banks case, which is cited into our motion. That's JC Development. These are the facts that you can take judicial notice of simply because it's on file with the government. And that's it. That's the end of the analysis. There's nothing else to be said on that.
What about the fact, and that you're relying on, is that we can take judicial notice at any stage of the proceedings? Any clarity on what it means by proceedings? Does that mean in the life of the case or simply when the rules of evidence apply? Because right now, we're just in a pretrial motions phase and the rules of evidence don't apply.
Right, and I think that the statute is plain on its face. It's 201 subsection F, any stage of the proceeding, and that's it. I think the Riley case, consider judicially noticed facts on appeal. The cases we cited to before, Doman, Jackson, they're in our motion as well. I mean, they're older, but they still stand for the proposition that you can consider judicially noticed facts right now.
But those cases where a court took judicial notice on appeal, that was after some formal evidentiary hearing of some kind where there was a record. Is that fair?
That's the Riley case. That's correct. Yes. But in the other two cases, Doman and Jackson, that was the courts essentially saying that, yeah, the trial court, you could take judicial notice of this on the demurrer stage.
Both of those cases were pre-evidentiary hearing?
Yeah, but both of those cases were the demurrer stage. That's correct, Your Honor. Yeah. And I think that's the point. So those two cases show, plus just literal language of the statute, subsection F, that you can take judicial notice of these facts right now. And then the Riley case also supports the argument too. It accepts the fact that the statute says you can take judicial notice at any stage of the proceeding. And I think that also makes perfect sense with just the purpose of judicial notice. In the Hunter case, which we cited to in our brief, Hunter v. Will, that Georgia Court of Appeals decision makes the point. The whole point of judicial notice is to negate the need for evidence of certain types of facts, which we just know. And we know these facts, that Sean was elected, he was qualified, and he's from Georgia, based on public records with our state government, the governor's office and the secretary of state. That's it. Stipulation has nothing else to do with any of this. It's that we have the records. We don't need any evidence to support these facts outside of these because these records are on file with the government. That's all I have to say, Your Honor, unless you have any further questions related to that matter.
No, understood. All right. So, Mr. Wakeford, last word to you. He's saying that, and I haven't had a chance to read these yet, but the Riley case, and I think there was another one he cited, that those potentially were also done at the demurrer stage. And then I'll also point out, I think the state had already agreed to judicial notice, for example, that the safe harbor litigation deadline had not been met back at the hearing in December, if I'm not mistaken. So what's the difference now?
Go ahead.
Judge, just on that brief point, as I recall, I don't think we ever in any context agreed that safe harbor had not been met.
Well, I shouldn't
maybe the
use
lawsuit
such a
was
loaded, well, let me clarify. I know that's a loaded legal term. What I think the judicial notice was is that there was a pending case related to the election lawsuit as of the date, the relevant date. And I think that was something that Defendant Schaefer had asked to take judicial notice of. And I believe when I put the question to the state, there was no objection to that.
I think in that limited context for that
Right.
limited issue, we didn't contest because there was lawsuit pending.
Right. And so I think I think the state is, and I understand why, kind of so hesitant and worried that it's going to seep into the demurrer segment. I'm just wondering where's the dispute among these three facts: that Mr. Still wasn't elected, Republican presidential elector, that he was qualified, and that he was from Georgia.
Judge, the indictment is premised on the allegation that he was not elected to any office. And so to say for
To any office.
I mean, subsequently to the Senate.
Yeah.
But this idea
Right.
that it's not in dispute that Sean Still was elected to be a presidential elector, I don't know what planet we're on that anyone thinks that that's not in dispute. That's literally why we are here today. That's why he's under indictment, because he was not elected to be a presidential elector. And then he went and held himself out to be one anyway.
But is the distinction they're trying to make that he was selected by the Republican Party to be an elector, and your indictment is talking about the actual
An
accepted
actual
elector?
An actual
Right?
real presidential elector.
I think it's an obvious distinction, and I don't see why admitting these judicial facts intrudes upon your legal theory.
And I'll turn it back over to
Yeah.
Mr. Wakefield.
I appreciate the time. I wanted to take a look at the Riley case and remember in what context that was raised. That was in their reply brief. I think starting just certainly with the one question you have, which is what's the harm? Why not? It's just, this is under Title 24. These are the rules of evidence, and that the rules of evidence don't apply at the demurrer stage because your honor's not considering evidence at the demurrer stage. That 24, that this statute as passed in 1981 is not inconsistent with that idea, because it takes specific pains to point out that the truth of any facts cannot be determined except by a jury.
So should we be unwinding what we agreed to in December when we were talking about there was a case pending at the time?
Was that in the context of a demurrer, your honor?
It was a judicial notice. Schaefer filed a motion for judicial notice that there was a case pending as of the date. It was the ECA litigation.
I'd have
right?
to go back and
Yeah.
look at the context, your honor. But to get finally to get to where your honor was leading us, the answer ultimately from the state is so what? Because the argument here does not hold water. It's not going to move the needle. If your honor takes judicial notice of these facts, just judicial notice, they are in the room without having to be proven in the normal course of business, which wouldn't be appropriate anyway because it's a demurrer. But they're in the room, but they're not shown to be true. They're outside the indictment. And even if they were taken as true, they still don't change the distinction your honor just pointed out. They don't change that he couldn't admit to the language in the indictment and be innocent of a crime. So it's going to survive no matter what. So I understand if we want to look at it completely isolated, the state's ultimate answer is going to be, so what? Doesn't matter. But I still maintain that the way that the code is laid out, it's indicating that that is not appropriate for a demurrer.
The code as laid out in 201, meaning you don't think this is qualifies as proceedings. Is that accurate?
That is correct. I don't believe so, because it would turn demurrer proceedings into battles of indisputably accurate documents, essentially, your honor.
Which isn't all that common. I mean, most of the time, the arguments we've heard so far, a lot of them have focused on intent, have focused on transcripts, things that just aren't ever going to fall under the judicial notice statute. This specific one, demurrers,
Demurrers,
Trying to
which are
find a
not
way.
appropriate because they stray outside the four corners.
right.
of the
And so what
indictment.
I'm saying is it may just, we haven't had an opportunity very often in Georgia to see the interplay between demurrers and 201. Maybe the Riley case does, as you said, you refreshed yourself on it.
No, it does not. I mean, in the criminal context, there is no interplay between, not anymore, not after 201 was passed. And the only cases that speak to this are the ones cited by the defendant from either about 80 years ago or more than 100 years ago, where the court did take judicial notice, I think, of whether a county is dry or wet. I mean, that's how antiquated these cases were. Or the list of corporations held by the Secretary of State because it was some kind of false certification as to a business license or something like that. It doesn't matter because the former definition doesn't apply once 201 is passed. And what 201 indicates to us is that judicial notice is about like short-circuiting the process of the laborious process of proving up the admissibility of something. Instead, your honor can just take judicial notice if it's from a reasonable source, but you're not supposed to be doing that at the demurrer stage at all. So again, we'll come back to where your honor was leading us a minute ago. The answer ultimately may have to be, you can take judicial notice, but it's of no use to you because it's still outside of what you're supposed to consider when you're considering a demurrer. And that's the four corners of the indictment.
All right. Well, we'll have to, if that is the case, we're going to have to see where the chips fall in with that December issue too, but we'll take a good look at that. So, Mr. Beaver, let's get to the heart of it, and you can argue whichever, assuming that this is judicially noticed, how it supports your demur, and if you want to see if you can do it even without that, feel free.
It'll be brief, Your Honor, if we can get it up. This is where this comes into play, Your Honor, because he has been charged with representing himself to be a elected and a qualified presidential elector from the state of Georgia. So that's in every one of the even numbered counts against him. Count 8, that phrase is utilized in the one having to do with impersonating a public officer. In count 10, it is used on the forgery in the first degree language. In count 12, it is used in the false statement and writings count. In count 14, it's used in the charge against my client for the criminal attempt to commit the filing of false documents. And in count 16, it's used with forgery in the first degree. In each instance, those three terms, elected, qualified, and from Georgia, are at issue. This is where we come into play. We are not on another planet. We're right here in Fulton County. The way that he was elected the way he was elected is determined both under the code sections that are cited there of 21-2, 134, and 172, that the political parties select their own presidential electors, and the Georgia Republican Party rule, which states that the Republican nominees for the Electoral College shall be elected by the State Executive Committee, provided, however, that such election may be by primary if authorized by the State Committee, certified to the Secretary of State as provided by law. So what do we have? We have from the governor's certificate of ascertainment that the following electors received a certain number of votes, with Sean Still's name being number 15 in the lineup, and which shows that Still was an elected Republican presidential elector, and that he was qualified. That comes from the Secretary of State's office, where their document, which shows the number of the qualified presidential elector candidates for the November 3, 2020 general election on the Republican slate for Trump and Pence, next to last is Sean Still, qualified as an elector. It also comes from, this is within our motion to take judicial notice, which we handed to the court, that he was a qualified Republican presidential elector. This is the document to Brad Raffensperger as a Secretary of State, which contains 67 pages where every one of the candidates, including Sean Still, named qualified to run in the May 19th, 2020 general election. The final document, I believe this is the final one,
When you
number
say
5.
the May 19th, you mean the primary?
Correct. Qualified to run in the primary. So he was qualified, which then,
The 2 million votes you referenced earlier, that's the primary election.
Correct.
Okay.
now this document is from the final election, correct? That's the overall document. It shows the number of Democrats on top, which has more votes than the Republicans. Then it shows the Republicans with 2.4. And then I think there's also one, and it's in the notebook, Your Honor. This is the one, I think it's an E, which was referenced previously, which has also the ones that the Libertarian Party received, 62,000 votes. The qualification are these two documents, both the listing from the Secretary of State, which may be document, let me see here for a moment. I think it's B, if I recall correctly off the top of my head. No, C. Yeah, this document is document C in the notebook. Then there is the document, which I believe is D. Yes, that he was qualified to run in the May 19, 2020.
I just want to go back to the first, you're saying you did the segment on Exhibit E where you said the following electors received 2.461 thousand votes. You're saying that in your definition shows that they were elected?
What it shows is that Sean Still, that's proof from the governor's office that if you go back, the only way you get onto that document is if he had qualified.
Qualified, yes. I'm trying to go back to the first element where you're saying they were elected
Okay. He was elected by the state executive committee.
to be.
That goes to
on the ballot.
the rule on A, and the only way you go from A to B in terms of the document is indeed if you have, if the party has indeed had that executive vote. So that's under A. The only way you get there is if you're elected by the state executive committee. So here's our point in all of this, is that if you have a literally true statement, an objectively true statement, that cannot form the basis of the crime of making a false statement against my client. We cite to both Spillers as well as the state. In Spillers, what it explains is that the defendant's statement, which was objectively correct under the law, could not form the basis of a false statement charge. And in Smith versus State, that the defendant's answer to the question was legally truthful and therefore cannot be held for false swearing. And it just makes common sense, Your Honor, is if you've got a situation where a statement is objectively correct, then you can't be charged with making a false statement. It's just the two are separate and apart from one another. It's a Venn diagram that doesn't intersect. So
Let me.
that's our point, is that he was elected,
Sure.
he was qualified, and he was from the state of Georgia.
I'm gonna try to see if I can come up with a hypo that may make no sense, but bear with me. Let's say there was an officer with the Atlanta Police Department who impersonates an officer with DeKalb County, and he's indicted for impersonating a public officer. And the language of the indictment said that he held himself out as a police officer, as a peace officer, and includes some extra language indicating it's because he called himself a DeKalb officer. Is essentially what your defense is coming in here and saying, well, he's been an APD officer the whole time, so that counts invalid. He was an elected and qualified elector, but the state's indicted him for being another kind of elected and qualified elector, which he was not. Am I tracking it all there?
Well, I think you're tracking it.
How does that not line up here?
What I would say is that, first of all, you've got to look at the exact false statement that he is charged with, the exact words. And if what you're charging the man with is making a false statement, then if the false statement is objectively correct, how can it be a false statement that he gets charged with?
But what's objectively correct if we've included an intent element about misleading, for example, in count 8, President of the Senate, archivist, and also talking about the certificate of the votes form that came later. How is that objectively true based on what you're saying, that because he was elected, because he was qualified, you satisfied everything in their indictment in the language?
What I'm saying is that at the time that he signed the two documents which are at issue, one being the certificate of ascertainment and the other one being the filling the vacancies, which are the two documents that he is charged with. When you read the statement that they have charged him with, that is that he was elected and that he was qualified and that he's from Georgia. If you've got someone who's reading that, if those three statements are true, even though it's in a different context than the state wants to paint it after the fact, when a person is looking at that statement and signs it and it's subjectively correct, then it cannot be charged with making a false statement because what they've signed is objectively true. And I mean, we would rely on again, the Spillers versus State and the Smith versus State to support our position that you can't have it both ways. It's very similar to a perjury case, Your Honor, where you've got to get someone nailed down in their testimony to where they're making an absolutely false statement. If there's any way that the statement that they make can be taken as being literally true, then it can't form the basis of a perjury statement. You've got to have an actual falsity for it to be the basis of the charge. That's what we're saying.
All right. Thank you, Mr. Beaver.
Thank you.
Okay, last word to the state.
Your Honor, I was watching a television show once where one character turns to another, says, "Are you even who you said you were?" And the other character says, "In a sense, yes, but in another truer sense, no." And that is essentially what this argument boils down to. It may be that Mr. Still was, in some senses, an elector, in some senses elected, duly or qualified, any of those things. It doesn't matter, because what he's accused of doing in 6 different counts, charging 6 different crimes, is claiming to be a presidential elector, or an elector for the office of President of the United States. And that is separate from just being called an elector or a Republican elector or anything else. In fact, OCGA 21-210 tells us explicitly that there shall be elected by the electors of this state, and their elector means something completely different, persons to be known as electors of President and Vice President of the United States, and referred to in this chapter as presidential electors. It's a separate thing. It's not the same. He wasn't accused of being a qualified elector from Georgia in just those 3 points. He was accused of being this, presidential elector, which is a discrete term in which he claimed to be in various ways, violating the law in various ways in these various charges. And it's not like he's charged with one count under 16-10-20 where he stood up and said, "I am a qualified elector from Georgia," which seems to be the tenor of his argument today. That is not at all what he's charged with doing. Each of these charges, as you look at them, states that he made use of a document, or he made a document that contained a false statement. And each time the falsity that's attributed to him is that he was holding himself out as a presidential elector, or an elector for the office of President of the United States, which is a discrete term in which he undoubtedly was not at the time that he said he was. So this is the "so what" portion that I was referring to, Your Honor, a few minutes ago. You take judicial notice of anything, whether the state objects or not, doesn't really matter, because 1, those facts are outside the face of the indictment. And 2, his argument doesn't address what's actually in the indictment, which is that this is what the state has said we intend to prove at trial. Ultimately, all of this may make a fine motion for directed verdict one day, but it's certainly not a demur, and it certainly doesn't support the claims that are put forward in the briefing. 21-210 is clear about what the office is. The indictment is clear about what Mr. Still claimed to be in various ways, and nothing that they have put before Your Honor would allow you to dismiss these charges on any basis. Are there any questions which I can clarify for Your Honor?
No, I think that covered it. Thank you, Mr. Wakeford.
Thank you.
All right. Well, thank you all for your argument today. And I think placing an emphasis on some of the decisions we'll have to make in sorting these out, procedural and substantive. So I'll just offer it if any of the parties are interested. It's by no means obligated, but if anyone wanted to submit post-hearing briefing on some of these finer points or questions, you're certainly welcome to. If so, I would ask who wants to do that and how much time you need. Mr. Beaver, just since you rise.
Respond to that, because that
Sure.
may depend partly what the state does, but I do want to call the court's attention to a court